Welcome back to our JIGL lecture series. This is the fourth video in our journey through chapter 1 of Jurisprudence, Interpretation and General Law lecture series. In the previous videos, we laid the foundation by understanding the meaning of jurisprudence, explore the contributions of key thinkers, and delved into the major schools of law. Today, we are shifting focus to a crucial aspect of theory, that is sources of law. This is where jurisprudence meets reality. We explore how laws actually come into existence and gain authority. We will break this down into two categories. One is primary sources. These include legislation, judicial precedents, customs, and personal laws, each playing a direct role in shaping enforceable legal norms. So these are the sources from which laws are made, means those all are enforceable. Then we have a secondary sources. These are more interpretative and philosophical, such as justice, equity and good conscience, and the influence of English law, especially in common law jurisdictions. Understanding these sources helps us trace the roots of legal authority and appreciate the dynamic interplay between tradition, reason, and institutional powers. Let's dive in now. Now we will begin by categorizing sources into two broad types, as we discussed, primary and secondary. Primary sources are the direct creators of the law. Legislation is the first out of that. This includes supreme legislations like acts passed by the parliament, like Income Tax Act or labor laws, etc. And then subordinate legislation such as rules and regulations made by departments or authorities under delegated power. Next one is precedents. Precedents are the judicial decisions that guide future cases. These are also called as a judge-made laws. Whatever a judge given a decision, those will be binding factors. These can be authoritative or persuasive and either declaratory or virginal. So we will go through one by one in detail in the later videos. The next important one is customs. Customs plays a very crucial role as a source of law, and custom is nothing but a long-standing practices recognized by the society. As a society, whatever they are following for a longer time. These include legal customs. Under legal customs, we have local customs and general customs, and also there is another category which is called as conventional customs. Finally, the personal laws are derived from different sources like Vedas and Qurans. So let us go through the sources of Hindu personal law and Muslim personal law. What are the sources for this? So this all becomes primary sources of law. And then comes a secondary sources which supports and influence the legal interpretation. First one is justice, equity and good conscience. These principles fill gaps wherever there is a law is silent. If there is nothing is written in a law, all decisions will be taken with keeping in mind justice, equity and good conscience. The other important sources for Indian laws are English laws, a historical influence, especially in common law countries like India, where most of the laws are derived from English laws. So these are shaping a larger extent structure of country's law. This framework helps us to understand not just what the law is, but why it is and how it reflects society's values, tradition, and institutional authority. Let's explore each source in detail. Let's begin with the most direct and authoritative source, that is legislation. In simple terms, legislation reflects the will of the people expressed through the act passed by legislation. Okay, it means these are the laws which are executed by parliament, who are elected members of the party, and they are called as the legislatures, and they made these laws. For example, Indian Partnership Act, Companies Act of 2013, Trade Union Act. All these are the acts, formal acts which are executed by legislatures. So each of these acts are formal declaration of a public policy and legal standards. No one should miss these legal standards. Everybody should follow these legal acts. The word legislation itself comes from two Latin words. First one is legis, which is nothing but law, and the second one is a latum, which is meaning to make. So literally it makes law making power. So who will get the law making power? Law making power, the legislatures who are elected members of the parliament and assembly, they are the one who are getting a power to make a law. What makes legislation unique in its existence is its sovereign authority. Okay, as they have the highest authority in the country, and everybody should follow whatever enacted law is there. So legislature is the only source that can enact new laws and repeal outdated ones. Any new laws, if country has to introduce, then it should come from legislation only. And then if any law it feels that it is outdated and it should be replaced or something, then also it can be done by only legislation. Once passed, these laws are binding on everyone, whether you are a citizen, your institutions, or even the governments. Everyone should follow this law. But how this law will be enforced? Before enforcing this law, it is made known to the lawyers. It is made known to the lawyers and judges and other social thinkers, ensuring clarity and consistency in legal interpretation and application. This is the most important part of legislation. Only legislators will not do this work. They will prepare with the help of executives, and then it will be given to lawyers and judges for the review to get a opinion, feedback on the system. In essence, legislation is the backbone of a legal system. It defines rights, duties, and procedures, and ensures that justice is not just a concept. Okay, it ensures that justice is not just a concept but a codified reality. What it means, every law will be having number of sections, right? So it is a coded, each point is coded, so it is a codified reality. It is not just a concept. I hope you are clear with the concept of legislation and how the laws are made. Let's now deepen our understanding of legislation by looking at its definition. According to Solomon, legislation is that source of law which consists in the declaration of legal rules by a competent authority. So rules given by a competent authority. In simple terms, it's a law made by those who are officially empowered to do so. Who are empowered to do the law? Elected members of the parliament or a legislature. Typically we call them as legislatures. Now let us look into a kinds of legislation. Legislations can be supreme legislation, subordinate legislation, and then sub-delegations. Supreme legislation is law made directly by the sovereign authority, the highest topmost authority, that's Parliament in India. It holds the highest legal status and cannot be challenged by any other body. So whatever law passed by supreme legislatures can be challenged or reviewed in a court, but otherwise those will stand as a highest authority in the country. Then comes subordinate legislation. Subordinate legislation is also known as delegated legislation. This is a law made by bodies under the authority of the legislatures. Under legislature, there will be many bodies. They will make the rules and regulations. Let us see municipal legislation, which are local laws made by municipal bodies, executive legislations, rules made by executives like a defense, etc., defense body, etc., like Defense India Act, Defense of India Act. Then we have a colonial legislation, laws which are made during colonial rules, some of which still influence our legal system. Autonomous legislation, laws made by institutions like universities and corporations, the how universities buy laws and then LIC or other large corporations of the government of India, they will pass their own legislations for day-to-day operations. And then comes judicial legislation. Sometimes courts interpret law in ways that effectively create new legal principles. The final classification is subdelegation. When a delegated authority, these all are like the local bodies or someone or executive department, they further delegates its lawmaking power to others. So then it is called as subdelegation. Then the question comes, why do we need delegated legislation? Why can't Parliament or a supreme legislation make all the law? Because it offers flexibility, handles technical complexities involved in the lawmaking process, and it also saves Parliament time, and it is useful in emergency situations or when secrecy is required. Like in matters of national security, all these are the key benefits why we go for delegated legislation. Otherwise, Parliament time will be wasted. And also Parliament requires some amount of technical expertise. So those things can be managed with subordinate legislation. This layered structure allows the legal system to be both adaptive and authoritative. It is authoritative structure, whatever supreme legislation says it is final, but at the same time it is also adaptive in nature. Let's now explore the concept of precedent, also known as judicial precedent. Precedent is a foundational principle in common law systems. A precedent refers to a rule or a legal principle that has already been established by a competent authority. Who is a competent authority here? Typically a court. So where competent authority established in a previous case with similar facts and circumstances. So for example, if a court has decided a particular issue in the past, that decision can guide future cases involving comparable situations. So precedents are nothing but previous decisions of the court, and that should be used by other courts in the next similar cases. The core idea here is fairness and consistency. The core idea why we need precedents, because this will bring a consistency in the decision making, judge decisions. So the fundamental principle behind this is like cases should be treated alike. This ensures predictability in the law and reinforces public confidence in the legal system. Judicial precedents are not just helpful, they are vital source of law. Okay. It is not just helpful for decision making, it is a vital source of law. Across time and jurisdiction, they have held significant authority. So that's why Jeremy Bentham famously put it, precedents are judge-made laws. And Keaton adds that judicial precedent is a judicial decision to which authority has in some measure been attached. Meaning it is not just any decision, but one that carries legal weight also. Importantly, precedents are binding on lower courts, so a decision of a high court or Supreme Court becomes rule of law for subordinate courts in future similar cases. However, the Supreme Court itself isn't absolutely bound by its past decision. It has the power to overrule them when necessary, allowing the law to evolve with changing times. In essence, judicial precedent strikes a balance between stability and flexibility in the legal system. Let's now understand how judicial precedents operate within the Indian constitutional framework, especially under Article 141. Article 141 states that the law declared by the Supreme Court shall be binding on all courts within the territory of India. So whatever decision or a decision given by Supreme Court are binding on all the courts within the territory of India. High Court, subordinate courts, tribunal, all courts are bound to follow Supreme Court decision. This establishes the Supreme Court as the highest judicial authority, and its decision become binding precedents for all subordinate courts and tribunal across the country. Now, within a high court, the structure of bench also plays a very important role. A single judge is the smallest bench, and two judges sits together. It is called division bench, and then when there are three or more judges preside, it's known as full bench. Importantly, decisions made by a larger bench are binding on smaller branches within the same high court. However, the decision of one high court is not binding on the other high courts. It holds only persuasive value, meaning other high courts may consider it but are not obliged to follow it. So remember, the high court decision of one will not be having any binding enforce on other high court decisions. Only they will be having persuasive value, means the other high court can consider this is what happened in another high court, but it is not binding on them. In contrast, Supreme Court is the highest court, and Supreme Court decision carry binding force nationwide. All courts and judicial tribunals must adhere to its ruling, ensuring uniformity and consistency in the interpretation of law across India. So what is the use of this hierarchical structure? The hierarchical structure of precedent ensures that legal principles evolve with clarity while maintaining respect for judicial authority and consistency in legal outcomes. Now we begin our exploration of the different kinds of judicial precedents. This slide introduces all major categories: declaratory and original precedents, persuasive precedents, authoritative precedents, which are further classified as absolutely authoritative and conditionally authoritative. Declaratory and original precedents, the remaining types we will discuss in the next slide. Declaratory precedents, let's start with declaratory precedents here. According to Solomon, a declaratory precedent is one that merely applies an already existing rule of law. It doesn't create any new law. It confirms and reinforces that what is already established. Think of it as a judicial saying the rule exists and we are applying it again. So already law has been made, and which is people are aware of that law, and the same thing court is applied. These are common in advanced legal systems where the body of law is already well developed. So in a country like India, where already law we have developed, many acts have been passed, and if decisions is given based on those acts, right, then it is called as a declaratory precedents. Example, if court applies the principle of natural justice in a routine administrative case, it's reaffirming an existing rule. This is declaratory. Then original precedents, in contrast, are far more dynamic. These are decisions where the court lays down a new legal principle, essentially creating a law for the future. Though fewer in number, these are very few in number because normally always all precedents will be a declaratory precedents already which is established, it will be applied. But in some cases, the new rules or a precedent can lead to a creating of a new law. So these are in fewer numbers, but its impacts are very big. A powerful example for this is Vishaka guidelines laid down by the Supreme Court of India in Vishaka versus State of Rajasthan in 1997. In the absence of specific legislation on sexual harassment at the workplace, the court formulated binding guidelines. These acted as a law until the enactment of Sexual Harassment of Women at Workplace Act 2013. Now let's turn to persuasive precedents, a category that plays subtle but significant role in judicial reasoning. A persuasive precedent is one that judges are not legally bound to follow. However, they may choose to consider it and often attach substantial weight to it if they find it reasoning is compelling or relevant. If judge found that these precedents are good to apply, he can do it, but it is all completely discretion, or he can use certain portion of the previous judgment. Okay, persuasive, it is not a full binding on them, it is on the discretion of the judge. Whether he wants to apply, he can apply it, otherwise he can ignore it. These precedents serve as intellectual guidance rather than binding authority. So it is not a mandatory for judge to use, but it gives intellectual guidance. Example of persuasive precedents are, in India, decision of one high court are considered persuasive in other high court. For example, ruling by Bombay High Court may influence a decision in the Madras High Court, but it is not obligatory. Similarly, ruling from foreign courts such as those from England or the United States are treated as persuasive. They may be cited for their reasoning, especially in areas where Indian laws are silent, but again it is not obligatory. Another example is obiter dicta. Obiter dicta means remarks made by a judge that are not essential to the decision. Again, they do not form any part of judgment, but these are the notes made by a judge. This can be considered and this will have a persuasive value, not a binding force. Let's now explore authoritative precedents which differ significantly from persuasive ones. An authoritative precedent is one that judges are legally bound to follow, regardless of whether they personally agree with the reasoning or outcome. These precedents carry the force of law and must be obeyed by lower courts. We can break authoritative precedents into two categories: absolute authoritative precedents and conditional authoritative precedents. Absolute authoritative precedents are the most rigid form of precedent. Okay, their binding force is absolute, meaning the judge has no discretion. They must follow the decision even if they believe it to be incorrect. Example, in India, every lower court is absolutely bound by the decision of courts superior to it. For example, ruling by the Supreme Court is binding on all high courts and subordinate courts. This ensures consistency and stability in the legal system. Conditionally authoritative precedents, these precedents are ordinarily binding, but they can be disregarded under certain conditions. For instance, if the precedent is outdated. Okay, it is normally binding, but under circumstances we can ignore these precedents when it is a precedents are outdated, conflicts with the newer rules, or was delivering per incurium without considering relevant law. So the court may choose not to follow it. This category allows judicial flexibility, enabling court to adopt to evolving legal standards while still respecting hierarchy. Let's begin with the foundational principles that anchor judicial consistency. There are three key doctrines in precedents. One is stare decisis, second one is ratio decidendi, and the third one is obiter dicta. Here we will be discussing on stare decisis. Stare decisis is a Latin phrase meaning to stand by decided matters. This doctrine is central to the functioning of common law system, including in India. Stare decisis ensures that court follow previous decisions. This isn't just tradition, it is a mechanism for maintaining consistency, predictability and stability in the law. I'm always saying that any decision given by one court or the higher court should be followed by the lower court. The basic reasons are maintaining a consistency, predictability and stability in the law. When similar cases arise, court rely on established ruling to guide their judgments. Right? Whatever is there previously, the same case, similar case, whatever decision given, the same decision will be given the new case also. In India, this principle stare decisis finds constitutional backing also. We discussed this already. Article 141 of the Constitution states that the law declared by the Supreme Court shall be binding on all courts within the territory of India. This elevates Supreme Court decision to be binding status, reinforces the hierarchy of judicial authority. So the Supreme Court has repeatedly emphasized that precedent is a vital for legal certainty. Okay, so why we need precedent? Precedent is vital for legal certainty. It promotes judicial discipline and ensures that courts do not deviate from the established interpretation without compelling justification. Let's explore now the concept of ratio decidendi, which literally means the reason for the decision. When judge reads out the decision, he also provides a detailed reason behind the decision. Okay, so in legal terms, it refers to the principle or rule of law that forms the foundation of court's judgment. Why judge has taken the decision, the reasons will be there in the ratio decision, that is called as a ratio decidendi, and this is the binding element of a judgment. Okay, it is part of the judgment and then everybody must follow this. Unlike obiter dicta is a notes which is made by judge that we will discuss later, but these all are the reasons behind the judgment, so that's why these all are binding factors. Why it is matter, like why ratio decidendi matters? Basically, identifying the reasons is crucial for understanding the precedent value of a case. Okay, to identify any value of the case, the reason behind the decision is a crucial one. It helps lawyers, judges and scholars determine what part of the judgment must be followed in subsequent cases. There are two important cases here. One is Keshavananda Bharati versus State of Kerala and the another one is Indira Gandhi versus Rajnarayan. In the case of Keshav Bharati versus State of Kerala, this landmark case introduced the basic structure doctrine. The court held that while Parliament has wide powers to amend the constitution, it cannot alter its basic structure. This principle became a ratio decidendi and has since guided constitutional interpretation in India. And the other case is Indira Gandhi versus Rajnarayan case. Here the Supreme Court struck down with the 39th Amendment asserts that democracy is part of the basic structure of the Constitution. This reasoning formed the ratio decidendi, reinforcing the doctrine laid in the Keshav Bharati case. So whatever the reasons given in the Keshav Bharati, the same thing used in Indira Gandhi versus Rajnarayan's case on 39th Constitutional Amendment. Let's now turn to obiter dicta, a Latin phrase meaning things said by the way. Things said by the way. These are the judicial remarks or observation that go beyond the core reasoning of the case. Core reasoning of the case will be there in the ratio decidendi, but other observations, whatever judge makes it, those are called as obiter dicta. Obiter dicta are not essentially to be the part of decisions, and therefore these are not binding on future courts. Only thing is stare decisis and ratio decidendi are binding factors, but obiter dicta is not. However, they often carry persuasive value. Of course, any judge remarks, the other judge can use it as a persuasive value, especially when made by respected judges or judges in any landmark cases. So why it matters? Why do we need obiter dicta also to be considered? Because it broadens the thinking of the judges. It offers ethical and philosophical insights for future cases. Here is one important case where ADM Jabalpur versus Shivkant Shukla. In this controversial case, Justice H.R. Khanna dissenting opinion, through though not part of the majority ruling, stood out a powerful moral statement. So what Justice Khanna said is, though it is not part of the major decision, but it will stay as a moral statement. His insistence on the inviolability of personal liberty during emergency became a guiding light for constitutional values and is often cited as a moral compass in Indian legal history. The other case is also the Arun Shanbag versus Union of India, where obiter dicta was considered as persuasive value. So far on the precedent side, we have gone through what is precedent. Precedents are nothing but judge-made laws, and precedents are binding to it's always binding on lower courts, like Supreme Court, whatever it gives decision, it is binding on all the lower courts, and High Court decisions are binding on lower courts under the High Court, but not to the other High Courts. So these all are the high level understanding on what is precedent and how it is going to be applied. Article 141 we discussed. Here we have few cases. Let us go one by one. Mira House versus Renal. This case emphasized the importance of recording judicial decisions. It established that lower courts can refer to and rely on previously decided cases to guide their rulings. This laid the groundwork for the doctrine of precedents in common law system. So the recording of the senior courts cases will help as a precedent for their decisions. Then Bengal Immunity Company Limited versus State of Bihar, a pivotal Supreme Court case that reinforced the supremacy of the Constitution. It clarified that no state legislation can override the constitutional provisions, especially in matters of interstate trade, commerce and Article 286. Most important case here is on T. Sarita versus Venkata Subbaya. The Andhra Pradesh High Court held that Section 9 of the Hindu Marriage Act, which allows restitution of conjugal rights, was unconstitutional. The court reasoned that it violated the right of privacy and bodily autonomy under Article 21. So this is a High Court decision, T. Sarita versus Venkatesh Subbaya case, where they said that Section 9 of restitutional conjugal rights in Hindu Marriage Act is unconstitutional. This is given by Andhra Pradesh High Court. Again, similar in contrast, Harvinder Kaur versus Harvinder Singh case, the Delhi High Court established or upheld that the constitutionality of Section 9 is not a violation of fundamental rights. It argued that restitution of conjugal right was a legitimate legal remedy and did not infringe upon fundamental rights. So there are two conflicting opinions from one Andhra Pradesh Hyderabad High Court and the second one is Delhi High Court. Again, in Saroja Rani versus Sudarshan Kumar case, the Supreme Court resolved the conflict by siding the Delhi High Court. Okay, so there was a different opinion from Andhra Pradesh High Court and there is a different opinion from Delhi High Court. The same section 9 is constitutional, that was told by Supreme Court in Saroja Rani versus Sudarshan Kumar case, and they supported Delhi High Court's decision. These cases illustrate how precedent evolved through judicial interpretation, dissent, and eventual resolution by the higher courts. They also highlight the dynamic tensions between personal rights and social norms in Indian jurisprudence. In this slide, we are comparing legislation and precedent, two fundamental or foundational sources of law that operate through very different mechanisms. Right, the legislations are passed by legislatures in a parliament. Precedents are passed by judges while making the decisions. Okay, so let's see one by one. Methods of reasoning: legislation follow deductive method. Laws are created in abstract and then applied to a specific cases. Okay, so laws will be created first and then will be applied in a cases. Precedent, on the other side, it is a inductive method. It applies inductive methods where first decision will be given and after that it will be used for other cases. So rules are emerges from decisions or a judgment in case of precedent. In case of legislation, it is first created and then will be applied. Knowledge before the decision. With legislation, the law is known beforehand. Everyone, we know what section 2 of the act says, section 10 of the act says. We know what act is, what it is, everything. Okay. But in the court, it will be pushed for enforceability. This is what law says and enforce it. But in case of precedents, the rule is formulated during the decision making and becomes applicable to future cases. Power, legislation is more powerful, definitely, because whatever legislation is having, like legislation is having complete power and it cannot be override or repealed by anyone else. Precedent, you have constitutive power. They help organize and interpret the law but cannot abolish it. Okay, they cannot abolish any laws, but the legislatures have a power to repeal, abolish any laws. The purpose of legislation is to make law. The purpose of precedent is to interpret and apply the law. Okay, so here the basic purpose in legislation is making a law, but in case of precedent, they will interpret and then apply the appropriate law. And then detailing wise, legislation is more comprehensive, clear and detailed. Everything is covered in this, but in comparison, this one is more focuses on particular case. Okay, it will not give a complete guidelines on every aspects of the topic. It will focus only on what is the case is, and then it could be used similar cases in the future. So this comparison helps us to understand how law is both crafted and shaped. Legislation where law is crafted and the precedents where law will get shaped through deliberate enactment and judicial interpretation. Both are essential for us. They serve different roles in the legal ecosystem. Now let's look into most important sources of law, which is customs. Customs refers to a bona fide practice or usage that has been observed by the people from generations to generation, often with no known, unknown starting point. Okay, the starting point of the custom is unknown. Custom is a general practice, whatever people are following from generations to generation. If you see at your home, there might be a lot of practices or customs which are being followed at your home, even in the society or in the community of yours, or in a country like India. There are many customs which are being followed, right from performing puja to marriages or rituals, all other things, right? It is all customs, and these customs are going to play a major role in a lawmaking process. See, to know it as a custom, it should be from generation to generations, and then it should be, we should not know when it is started. It should be unknown. Okay, starting point of the custom should be unknown. If you do start something today, it cannot be treated as a customs, and so it naturally emerges. Okay, it emerges naturally from the people's experience and shared values in the community. So according to Collins dictionary, a custom is activity, a way of behaving, a way of behaving or an event which is usual or traditional in particular society or circumstances. Okay, so this is a tradition which people are following in certain society. So custom, most important characteristics are custom grows out of practice. It is not imposed from the law. Okay, it is practice. It is considered the oldest source of law. So customs are considered as oldest source of law, predating written statutes and formal institutions. In this context, the people who make the law through consistent and accepted behavior. So, in a legislation or in the law, the legislatures are going to make a law. In precedents, judges are going to make a law. But in case of customs, right, people here, they are making a law, but they all are from immemorial and antiquity. It should be from generation to generation, and it cannot be a new. So few definitions here on customs. Austin defined customs as a rule of conduct which the government, sorry, it's a rule of conduct which the governed observed spontaneously and in pursuance of a law set by the political superior. He viewed custom as a subordinate to sovereign command. So what he says, it is a practice which people will do spontaneously, but the law created by the sovereign is highest authority, not the custom. And Solomon said, on the other hand, custom as the embodiment of principle that have commanded themselves to the national conscience. Principles of justice and public utility. His views emphasize the moral and society legitimacy of customs. Let's now understand how custom is not just a historical source of law, but also as a constitutionally recognized one of India's important law. Under Article 13(3)(a) of Constitution of India, the term law is defined inclusively. It states that law includes any ordinance, order, bylaw, rule, regulations, notification, custom or usage having in the territory of India. This means that the custom and usages, when consistently followed and accepted by society, can have the same legal forces as written statutes. Historically, custom played a vital role in shaping ancient Hindu law. Much of what we find in the Smritis and commentaries originated from a long-standing customs. In fact, Smritis themselves strongly recommended that customs be followed and respected, making them a reoriented force in the legal development. Modern legislation also reflects this recognition under the Hindu Marriage Act. Okay, so Hindu Marriage Act has given ample examples of recognizing customary laws. Few of them are as below. Section 7 allows Hindu Marriage Act to be solemnized according to the customary rites, and ceremonies of either party. Section 29(2) ensures that rights recognized by the customs are not affected by the provisions of the Act. Okay, any rights which is recognized by customs cannot be affected by the provisions of the Act, because in India, especially in southern India, a boy married to his sister's daughter. As a law in Hindu Marriage Act, there is a prohibition of provision degrees. Under that, at least 3 levels of marriages are not allowed, from a parent level or a grandparent level, 3 generations. But it is a customary practice in southern India, so it is allowed now. Okay, though it is Act prohibits it, as long as it is moral and it is not affecting the social culture, then it is allowed. The other important one is Indian Evidence Act 1872 also acknowledges custom as a source of law. Section 13 of Indian Evidence Act deals with the relevancy of facts when the existence of a right or right custom is it in question. This allows courts to consider customary practices as evidence in legal disputes. Let's now explore the different types of customs which are recognized in legal theory and practice. We begin by distinguishing customs based on whether they carry legal sanctions or not. Customs without legal sanction, customs without sanction, and custom with sanction. These are the 2 broader categories. Customs without sanction are non-obligatory. They are followed not because the law demands it, but due to social pressure or a public opinion, it will be followed. These are just referred as positive morality and nothing on enforceability. So these lacks any enforceability in the court of law. Customs having sanctions. Customs having sanctions are those that are enforced by the state, and these are legally recognized. These are broadly classified into legal customs and conventional customs. What is legal customs? Legal custom is a custom that has been formally recognized by the law and is enforceable in the court. It holds the same authority as statutory law when it comes. Those are broadly classified, again, local customs, and another one is general customs. Local customs exist within a specific locality or a community. They are binding only in that geographical or a social context. Whereas general custom, unlike local custom, these are not confined to any particular area. They are widely accepted and may influence national legal standards. So another important category is conventional customs. Conventional customs is which arises from the express or implied agreement between the parties. For example, Mr. A keeps supplying 10 liters of milk every day. So it is implied that both the parties know every day this A is sending 10 liters of milk. If all of a sudden Mr. B says that this is wrong, why you have sent, then I don't pay for it. So that is wrong, because it is already implied that every day is taking 10 liters of milk, right? So this arises. See, conventional custom, sometimes it might be expressed or sometimes it is implied. So whatever the example I gave, it is an implied agreement. It is not imposed by law. Okay, remember that conventional customs are not imposed by law, but accepted through mutual understanding. It will be accepted if there is a mutual understanding on it, and if both of them are clearly known about the fact, like this must be convention must be clearly established and known to both the parties, then it is accepted in the court. So there is no fixed duration is required like other customs, right? It should be from generation. No, if there is, as long as a reasonable amount of time is there, then it is accepted as conventional custom. But most importantly, conventional custom cannot override general law. They operate within the boundaries of general law. Let's explore the foundational qualities that elevate a custom to the status of law. The first one is immemorial or antiquity, like it must be followed from generation to generation. The start date of the custom should not be known to anyone. Then certainty, a valid custom must be clear and definite in its content and application. Ambiguity, if there is any ambiguity, it undermines its authority and legal recognition. Then reasonableness, custom must align with rational standards. They should not be arbitrary or oppressive, but rather reflect fairness and practicality. So some rigid customs, sati system or something, those are not accepted. The custom should be reasonable enough. Then these should be compulsory observance. The custom must be consistently followed as a binding norm, not merely out of convenience or a habit. Okay, everybody should have been followed this. Cannot be used as just escaping from certain situations. So there should be a compulsory observation in the locality or in a society. Of course, whatever is there that cannot be considered, whatever is people are following, that cannot be considered as a lawful. It should be conform with some portion of the law and also public morality. It must not contradict our statutory laws or offend social ethics. Legality and moral acceptability are essential for its legitimacy, right? So anything which is against the law, right, having a gun without license, if it is even your customs, but you should carry a license. That's the essentiality of a law. So every custom, sometimes it also should conform with the law, because otherwise it create social chaos. Unanimity of opinion. So the whole community, right, must accept the custom broadly and without any significant dissent. This consensus reinforces its normative power. If anybody, like within the community, if 50% of the community says it is not a custom, then it loses its authoritative power. And peaceful enjoyment. The custom should have been practiced without dispute or interruption, indicating its acceptance and stability over time. Consistency, as we already discussed on certainty side, and the consistency, the same thing must be uniformly across similar situations. It must be applied uniformly across similar situations. Inconsistency weakens its claim to be a custom. Together, these requisites ensure that custom is not only ancient but also it is just accepted and legally sound. They form the critical criteria by which courts and scholars assess whether a practice deserves recognition as part of customary law. And now let's look into the sources for personal laws, how personal laws derive from various practices and other religious texts. In India, we have two major personal laws. One is Hindu law and another one is Muslim law. Let's see what are the sources for Hindu law. Hindu law is derived from a rich body of religious literatures and evolved customs. Its primary sources includes Shruti, literally meaning what is heard. Shruti includes four Vedas: Rig Veda, Yajur Veda, Samaveda, and Atharva Veda. These are considered the most authoritative text in Hindu tradition. Then comes Smritis. These are recollections and teachings handed down by ancient sages or rishis. They interpret and elaborate the Vedas. The principal Smritis are Manusmriti, Yajnavalkya Smriti, and Narada Smriti. Then commentaries and digests. These are various scholars who wrote detailed commentaries on the Smritis, which help to shape the classical Hindu law. In modern India, Hindus are governed by personal law, that is Hindu Marriage Act, as modified by statutory law, and customs are still part of it, such as areas like inheritance and succession, marriages and adoption, co-parcenary and partition of joint family property, principles of pious obligation of sons to repay the father's debt, guardianship, maintenance, and religious or charitable endowments. All these are based on the traditional sources of Hindus, like Shrutis, Smritis, and then commentaries. Moving on to our sources of Muslim law. Muslim law or a Sharia is primarily based on divine revelation and the teachings of the Prophet. Its key sources are the Holy Quran, the foundational text of Islam, believed to be the word of God revealed to Prophet Muhammad. Next is Hadith or Hadiths. They are the sayings, actions, and approvals of the Prophet Muhammad. Though not written during his lifetime, they were preserved and transmitted by his companions. Ijmas, this refers to the consensus of opinion among the Prophet companions and early Islamic jurists. It reflects collective reasoning on legal matters. Then comes Qiyas. This is reasoning by analogy used when it cases is not directly addressed in Quran, Hadith, and Ijma. Commentaries and digests, two of the most influential works in Muslim jurisprudence. The Hidayah, composed in 12th century, and then Fatwa Alamgiri, compiled under the orders of Emperor Aurangzeb. These personal laws continue to operate within the Indian legal system, particularly in family law, and are respected as part of the country's pluralistic and legal heritage. Let's now turn to a vital secondary sources of law in India, one that fills the gap when statutes, customs, or personal laws fall short. The principle of justice, equity, and good conscience was formally introduced through Impeach's regulation of 1781. During the colonial period, it was designed to guide judicial decision making in case where no clear legal rules existed. In personal law disputes, Indian courts are required to apply the personal laws of the defendant, but only if the issue is not already governed by statutes or customs. This ensures fairness and respect for individual religious or cultural identity. However, when no statutory laws, custom or personal laws applies, court invoke doctrine of justice, equity, and good conscience. This essentially means applying principles that are fair, reasonable, and morally sound. Historically, this is often involved drawing from an English law, but only to the extent that such rules are suitable to Indian society and circumstances. The court are careful not to transplant foreign norms blindly. They adapt them to local realities. This doctrine reflects the judiciary role in upholding fairness and moral integrity, especially in a complex or a novel cases. It's a powerful reminder that law is not just about rules, it is also about values. And other secondary sources is English law. Let's go dive into that. Apart from the justice, equity, and good conscience, the other source of Indian laws are English laws, because most of the Indian laws are initially derived from English laws, which are passed during colonial period. Uh, the first one of this is common law. These are the principles built over a period of time in Europe. So this will be, sorry, in UK. So that will be used. Then we have a law of merchant. It is applied for a business and traders. That is also important source for us. Then principle of equity. Based on the principle of equity, where one who sees equity must do equity. One who comes to equity must come with a clean hands. Based on this principle, the equity also will be considered, which is already we discussed in the first source of secondary sources. And then statute of law, law enacted by the governments or delegated legislative bodies. So all these things are part of English laws. From English law, we have taken common law, law merchant, and then principles of equity and statute laws. All are the sources for Indian laws. Here are one or two slides on mercantile law, how mercantile law in India evolved. This is one of the part in your syllabus on JIGL. So we are touching it to why only mercantile law was given in detail. That I really not aware of it, but yes, let's see how mercantile law is evolved. Mercantile law is what we all know, that mercantile law is related to a commercial activities where trading is happening, buying and selling is happening. So in India, sources of mercantile law are law of merchant, statute laws, common law, and principles of equity. So we have borrowed a lot of things of Indian Contract Act, right, of 1872. We borrowed from English mercantile law many things. Most of the laws which are passed in India on mercantile law are during our colonial ages only. Indian Contract of Act of 1872, Sale of Goods of Act 1930, Partnership Act of 1932, Negotiable Instrument Act 1881, Arbitration and Conciliation Act 1996, the new one, Insurance Act 1938. These all are the legal provisions or statutes for mercantile law in India now. And some precedents. Always see, mercantile law is having a source. One is English law. Second one is the statutes which are passed in India. Third one is precedents. Precedents are nothing but judge-made laws, decisions in similar cases in the previous cases. And then customs and trade usage. What are the practices, what they are practicing in the trade, right? Sometimes whatever there is a general practices within some communities, all those things will become part of mercantile law. With this, I'm concluding the videos on chapter 1. In the next video, we will dive into chapter 2, constitutional law. If you found this helpful, please subscribe to the channel and don't forget to share it with your friends and classmates who might benefit from this content. Thank you so much for watching. Let's meet again in the next video.